Please get ready for a dictation of exercise number 21. It is a legal exercise and it is from October 2021 issue of the Progressive magazine. 5 seconds. Start. In 2009, Corporate Power Limited set up a thermal power project in Jharkhand and for so doing availed of loan reason facilities from various lenders, including the State Bank of India. The account of the corporate debtor was declared as a non-performing asset by SBI on 31/7/2003. On 27/3/2015, SBI issued a loan recall notice to the corporate debtor in its capacity as the lender's agent. On 31/3/2005, some of the original lenders of the corporate debtor, namely India Infrastructure Finance Company Limited, SBI, State Bank of Hyderabad, State Bank of Bikaner and Jaipur, assigned the debts owed to them by the corporate debtor to the appellant, the Asset Reconstruction Company India Limited. On 26/2015, the appellant issued a notice under Section 13(2) of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002 on behalf of itself and other consortium lenders to the corporate debtor. On 1/6/2016, the appellant took actual physical possession of the project assets of the corporate debtor under the Act. On 26/12/2018, the appellant filed an application under Section 7 of the Insolvency and Bankruptcy Code 2016 before the National Company Law Tribunal, Calcutta, for a default amounting to Rs 6,000 crores from the corporate debtor. As the relevant form indicating the date of default did not indicate any such date, this was made up by the appellant on 8/11/2019 by filing a supplementary affidavit before the NCLT, specifically mentioning the date of default and annexing copies of balance sheets of the corporate debtor, which, according to the appellant, acknowledged periodically the debt that was due. On 19/2/2020, the Section 7 application was admitted by the NCLT, observing that the balance sheets of the corporate debtor, wherein it acknowledged its liability, were signed before the expiry of 3 years from the date of default, and entries in such balance sheets being acknowledgements of the debt due for the purposes of Section 18 of the Limitation Act 1963. In an appeal filed to the National Company Law Appellate Tribunal, the corporate debtor relied upon the earlier full bench judgment. After a preliminary hearing, a 3-member bench passed an order on 25/9/2020 doubting the correctness of the majority judgment of the full bench and referred the matter to the acting chairman of the NCLAT to constitute a bench of coordinate strength to reconsider the judgment in V. Padma Kumar. A 5-member bench of the NCLAT, while the impugned judgment refused to adjudicate the question referred, stating that the reference to the bench was itself incompetent. Shri Ramji Srinivasan, learned senior advocate, appearing on behalf of the appellant, has assailed the impugned judgment, arguing that the majority judgment of the full bench of the NCLAT in V. Padma Kumar was clearly as per law, as it has not considered various binding judgments of this court, and that the said judgment was wholly incorrect in rejecting the reference out of hand at a preliminary stage. For this purpose, he referred to a number of judgments of this court in which it has been made clear that wide section 238A of the IBC, section 18 of the Limitation Act is applicable to a proceeding under section 7 of the IBC. Also, according to the learned senior advocate, the judgments of the high courts and the judgments of this court have expressly held that entries made in signed balance sheets of the corporate debtor would amount to acknowledgements of liability and have therefore correctly been relied upon by the NCLAT on the facts of this case. He argued, relying upon certain judgments, that the reference made to the 5-member bench by the 3-member bench was perfectly in order and ought to have been answered on merits. He also argued that the constitution of the 5-member bench, which passed the impugned judgment, was not in order, as 3 out of the 5 members of the said bench were members who assented with the majority opinion in V. Padma Kumar, the dissentient member not being made part of the bench so formed. This, according to him, was contrary to the principles of natural justice. He also argued that the fact that a balance sheet has to be filed under compulsion of law does not mean that an acknowledgement of debt has also to be made under compulsion of law, and for this purpose he referred to 2 High Court judgments. Refuting the aforesaid submissions, learned advocate, appearing on behalf of the respondents, argued that the explanation to Section 7 would preclude the application of Section 18 of the Limitation Act. Stop.